Okay. Okay, we're starting our afternoon docket. Our first hearing is special exceptions. Counsel, go ahead and state your name and your cause number.
This is Kevin Colquitt on behalf of Sabadia and Company. The cause number is DC 23-02207.
Okay.
Luke Motley here for the defendants, counter plaintiffs, Chesa Hartfield, Reggie McFall, and Keith Franklin.
All right, you may proceed.
Yes, Your Honor. My law firm represented the other parties, both the plaintiff and the defendants, counter plaintiffs, in a whistleblower suit. Now there's a dispute between those parties with regard to some monies lent back and forth and how to divvy up those funds. My law firm doesn't have a dog in this fight at all. We're agnostic as to the outcome of the dispute between the two sets of parties here. We've been recently brought into this suit and identified as a quote unquote interested party. We haven't been brought in as a third party defendant or as a counter defendant. And that's really extra procedural. There's no mechanism in the rules of civil procedure to identify someone, make them a party to the suit, but not be a defendant or a compulsory plaintiff. Here, I don't know what our purpose in the complaint is. Based on the allegations, there's ambiguity as to what our legal jeopardy, if anything, is. If there is legal jeopardy, I'd like to know what that is. And then, if there is a dispute, move to compel arbitration, because I have arbitration agreements with each of the parties to this suit. And if there is no legal jeopardy to Sabadia and Company, I'd like to move to be dismissed from the suit. I don't want to be a party to a suit and subject to discovery and have to attend trial and attend mediation, all those things that parties have to do if there's no justicable interest that Sabadia and Company has in the outcome of this case. So to be more, that's an overview. To be more specific about what kind of clarity I'm seeking on the special exception, if you go to the prayer of the Mr. Motley's client's counterclaims, prayer number 1, well, we'll start off with damages. It seeks damages, but doesn't say from whom. I don't know whether Mr. Motley's clients are seeking damages from Sabadia and Company, or if they're not. If they're not, they don't appear to be by the charges, but I don't want to be ambushed at a trial, and it turns out that someone's seeking a monetary judgment from my law firm without knowing about it. And the same with the declaratory judgment. If the declaratory judgment isn't going to require Sabadia and Company to do anything, isn't going to put any, burden on Sabadia and Company, then I don't see a reason why we are in this case in the first instance. And if it's going to do something, I'd like to, move the court to compel arbitration per the arbitration agreements we have with all the clients here in this case. So the first clarification I'd like to see on the special exception is from whom Mr. Motley's clients are seeking damages.
All right, Mr. Motley, just a second, Mr. Motley.
Yeah, Your Honor, I can address this. I think most of what he said pretty quickly, but I think there is a little background. I'm sure the court's read the petition, and this stems from an FCA case, False Claims Act case, where there was a $14 million settlement. And my 3 clients, along with Mr. Fisher, were the co-relators. Mr. Fisher was kind of
the what? I'm sorry. You said what? The collators?
Co-relators. It's
co-relators. I'm sorry, I misunderstood you.
Yeah, it's a federal Whistleblowers Act, and under that settlement agreement, there was a settlement of $14 million, 8.5 of which went to the government, and 27.5% of that went to as part of the co-relator share, which is a little over $2 million. Then there was a $5.5 $6.6 million of that $14 million that went to statutory attorney's fees and expenses. And so we're not really fighting over, there are two agreements that we've asked the court to construe. One is a sharing agreement related to the co-relator's share of the settlement, and that's between Mr. Fisher and my three clients. And then the second agreement is the Sabady representation agreements, and Sabady, those agreements are between Sabady, Fisher, and my three folks. And our claim is against Mr. Fisher based upon our interpretation of the Sabady contract, where there was roughly $2.5 million of the statutory attorney's fees and expenses that were paid not to attorneys, but to Mr. Fisher, who is not an attorney. And under the Sabady agreement, and what we're asking the court to declare are the rights and obligations of the parties under that Sabady agreement. That's why I included Sabady in the lawsuit, because as I read the deck action, folks who have an interest or a claim in the subject matter of the proceeding are required to be included. And I believe if we're asking the court to interpret Sabady's agreement, then I would have thought that they would be interested in how that's done. I'm not too worried about it. If the court says they don't need to be included, what I don't want to happen is when we get to trial or get to a summary judgment hearing, that the court say, hey, wait a minute, we don't have Sabady here, and they're a party to the contract. And so that's why they're included, because I think, well, it's obvious they have an interest in how those things are, how the contract is interpreted. And I have heard Mr. Colquitt's argument, and I've actually, my understanding is they don't have a dog in the fight, and we don't have a dispute with them as long as they don't have a dog in the fight. And as long as they don't pick sides, because the agreements, if the court looks at them, I think the intention was for Sabady not to be a referee between the parties. And I don't think I guess what I'm hearing from Mr. Colquitt and from Mr. Sabady in prior discussions are, look, that money went to Michael Fisher, and he's the one that's supposed to be divvying up. That's not our deal. And if that's the case, I'm fine with that. I think under the statute, under the act, I think they have to be included as an interested party, because we're basically interpreting, or the court's going to be interpreting, the contract that they're a party to. And that's why they were included. As far as arbitration, I don't know what we would arbitrate, because as it sits here today, I don't really have a dispute with Sabady. They're simply listed as an interested party because the contract that you're going to be construing, they're a party to.
Okay, response?
So as to being a necessary party, the Supreme Court of Texas has recently spoken on a similar case, and it's when a party must be joined as part of a declaratory judgment action. And that Supreme Court case is In Re Kappenmeyer. It's 668 Southwest 3rd 651. And that was an opinion that was just released actually earlier this month. And it says,
how do you spell Kappenmeyer?
I'm sorry, Your Honor. It's a Kappenmeyer, K-A-P-P, M as in Mary, E-Y-E-R.
Okay, go ahead.
And in that case, they say basically you look to Rule 39 of the Texas Rules of Civil Procedure. And it says, persons to be joined are someone who's in his absence, complete relief cannot be accorded among those already parties, or two, he claims an interest related to the subject of this action. Well, we're disclaiming a interest in the subject matter of this action, so Part 2 would not be applicable. So number one, we should only be joined in the if in our absence, complete relief cannot be accorded among the parties. And this is where we wanted to seek clarification in the relief sought in the petition, because the petition has a prayer for relief that doesn't say they're seeking a judgment against Michael Fisher. It just says we are seeking a judgment without identifying whom the judgment will be against. So if there's no judgment being sought against us, I think complete relief can be provided to the parties without us being involved. If there is some way a judgment that is going to be brought that's going to affect, our interest, where we're, a judgment to say Sabady pays some money or Sabady, you need to do X, Y, or Z, then I think then we would have, be a necessary party in this case. And that's the point where we would, seek to compel arbitration per our agreement with Mr. Motley's clients.
May I respond briefly to that, Your Honor?
Sure.
There's also a Supreme Court case as well that kind of addresses the issue that I'm talking about. It's Clear Lake City Water Authority versus Clear Lake Utilities, 549 Southwest 2nd, 385. And it basically goes through and cites the language of the Declaratory Judgment Act. And it says, persons, quote, who have or claim any interest which would be affected by the declaration is mandatory. That's the reason I included Mr. Sabady firm in the suit, because they have an interest. They may not be claiming an interest right now, but they have one with respect to how their contract, the retainer agreement is reviewed and interpreted. And the case also talks about subdivision A of Rule 39 and the Declaratory Judgment Act, says they're both mandatory provisions, both provide slightly different language. And this was a case where there was a couple of different contracts and one party sued.
Give me a second here. So
Sure.
I'm reading paragraph 22 of the plaintiff's petition, I believe.
All right.
And it says, there is an immediate dispute between Fisher and correlators about whether the correlators are entitled to anything further from a settlement of an FCA action against JP Morgan Chase. Fisher contends correlators have been paid all they are owed under the parties' agreements. The correlators contend they are owed more. And Mr. Colquitt, your client is a correlator, correct?
No, Your Honor. We were the law firm that represented all of the relators in this lawsuit, the case. We represented Mr. Motley's clients as well as Mr. Fisher in the underlying whistleblower case.
So are you claiming any addition? Have you been paid out of the settlement, or have you already been? Your client already been paid? I guess your client already been paid?
Yeah, I'm a partner at the law firm, so I think it's kind of interchangeable. Yes, Your Honor, we have received everything we believe we're due from our representation. We're not seeking any additional money from anybody in this case, except to the extent that we incur attorney's fees, what we believe needlessly. At this point, though, we're not seeking anything. And I don't think from reading Mr. Motley's petition and Mr. Fisher's petition, I don't believe anyone's seeking any additional money from us. I don't think anyone's saying that we didn't pay them money that we owed them. So I think from our perspective, our involvement in this case is finished. And we don't, we understand that our former clients all have a dispute with each other. But that's for them to, decide before Your Honor, and we just don't, quite frankly, rather not be involved in it.
So I guess I'm confused, Mr. Motley. Why are they in this case if they're not? They've been paid. Nobody else. They're not claiming any additional money. Why are they in the case?
They're in the case, Your Honor, because of the interpretation of their contract. All the money went through Sabady. They took their attorney's fees out. We're not fussing about that. What we're fussing about is they paid Fisher $2.5 million in the statutory fees, and under their agreement with all four correlators, it says funds not paid to attorneys belong to the clients, of which there are 4, my free folks and Fisher. I'm not fussing with Sabady because I think under their agreement, they paid Fisher all of it, and Fisher was supposed to divvy it out between us. That's what I'm hearing Mr. Colquitt say. And if that's the case, we don't have a problem with that. We just thought that they have an interest in how their contract's interpreted. Now, obviously, if they come in and say, well, no, Mr. Fisher's entitled to all of it under our contract, then yeah, we would have a dispute, but that's not what I'm hearing or what I've heard today. And I think that's right.
Were your clients of Mr. of Sabady?
Yes, they were. We each had a.
Are you claiming that Sabady's law firm breached their fiduciary duty or their contract in paying Fisher?
No, because I don't believe that. I think what they're saying is we don't have a dog in this fight. We gave the money to Fisher. Fisher's supposed to divide it up between the co-relators because he was kind of the lead co-relator. And I'm assuming I'm stating that right. Is that right, Mr. Colquitt?
Well, Your Honor, is it okay if I respond to Mr. Motley?
Sure.
And I would go up to the point where I don't think we're agreeing or disagreeing with what Mr. Fisher should have done with the money we paid him. We don't have a dog in that fight, so we're not taking sides. I understand that Mr. Fisher thinks that he did not have to pay money to Mr. Motley's clients, and I understand that Mr. Motley's clients believe that Mr. Fisher should have paid them some money. We're agnostic as to how the court, I'm assuming it's going to be this court's ultimate interpretation of the contract that controls what this court decides on that issue. That's between them. We have no interest in that outcome. As long as no one's seeking a monetary judgment against us or seeking any kind of injunctive relief that requires us to, take some kind of action, we shouldn't be a party to this suit. And to the extent someone is seeking monetary relief against my firm or is seeking injunctive relief, I would like to.
I get it. I'm going to grant this. I'm going to grant the special exception. You're required, Mr. Motley. I guess I'm trying to get to the end point, but we're not there yet. So at this point, you just need to replead. And if you're seeking money against the co-relators, you need to say who you're seeking money against. That's the first issue. Mr. Colquitt, what was the second issue?
That was where I was going to go. I was going to say if they're seeking either monetary relief against our firm or seeking any kind of declaratory, any kind of injunctive relief against our firm, something that requires our firm to do something. I just want to have notice of what that relief is, so we can defend ourselves appropriately. If they replead and there is no relief being specifically sought against my law firm, I suspect, I'd request that Mr. Motley just, non-suit us from the case, because we don't really need to be a participant in a case where we're not seeking a judgment or not seeking a judgment, or alternatively, we could, file a motion to dismiss if there's a petition filed where we're named as a party, but no relief is being sought against us.
That's granted and makes perfect sense. With the declaratory judgment action, if you don't have a dispute with the Sabady firm's interpretation of the contract, then I wouldn't think you would have declaratory judgment. But the risk is that at the end, if you do have a dispute with them and they defend it, then one or both of you could recover attorney's fees in the declaratory judgment action. I guess I've never had a situation where it was, I guess I'm still unclear. It's dispute isn't really with Sabady's interpretation, it's with Ryan's interpretation, Fisher's interpretation of the contract. But anyway, you need to clarify this, because I agree that looking at the petition, it is not clear. So you need to do that. You need to replead within 7 days. Mr. Colquitt, you need to prepare an order on the special exceptions. You need to say that this here at the beginning, instead of on this date, that this was heard on December 11th. You need to share a copy of the order with Mr. Motley. Mr. Motley, you have 4 hours to sign off on it, business hours. And then, Mr. Colquitt, I need to get this to my office, e-filed and emailed by Friday morning.
Okay, I'm on it right now, Your Honor.
Thank you, guys. You have a great rest of your day, okay?
Okay.
Appreciate it.
Thank you.
Bye-bye.
I'm going to take a very quick break. I'll be right back.
I don't know if anybody can hear me. Hey, Gwen, can you hear us? Okay, is loud enough for you?
Yes, I can hear you.
Okay, awesome. We're just testing it. Thanks a lot.
Okay, can you guys hear me okay?
Yes, Your Honor.
All right. Tony, are you ready?
Yes, Judge.
Go on the record on DC 20122875, Crossman versus USAA General Indemnity Company. Counsel, make your appearance.
Good afternoon, Your Honor. Gwen Bella for the plaintiffs.
Lisa Sanji and Melanie Fry on behalf of USAA General Indemnity Company.
All right, well, the first thing I'm going to say is it appears like something maybe got lost in translation. You guys provided me a notebook, but it only looks like it has the defendant's briefing in it. Did you not include the plaintiff's briefing in this, or was?
Your Honor, plaintiff did not file any briefing until this morning. I received one of them about, I guess, 8:30 this morning. She filed it, and the other one she filed around 10:30 this morning.
Yes, Your Honor, mine were filed quite late. We did deliver a notebook though with those to your office that I think was delivered about 11:30.
Okay.
Which should be there somewhere, but yes, they were filed late.
Yeah, that's not great. All right. Gary, can you ask Rhonda two things? Can you have Marissa come in here? And also, there's a second notebook on the Crossman case that just got delivered. I need that. Okay. So I guess my main issue kind of reading this, or I guess there's two issues. One is the issue of whether or not under Menchaca, MENCHACA, that you can recover damages. I haven't read your new briefing, and so what is your position on that, Ms. Bell?
Your Honor, I absolutely believe under Menchaca we can cover the damages. I think Menchaca is overstated by the defendants in this case. If Your Honor will allow me, I can go through provisions of Menchaca in about 3 or 4 minutes, and I think that will clear up our position.
Okay.
Let me see if I can share a screen here. So Menchaca was a Texas Supreme Court case with USAA as the defendant, with a plaintiff suing for breach of contract and unfair settlement practices. Not too different from this case. But a big difference is that Menchaca, the plaintiff in that case, only sought benefits under the policy. So her damages that she said, she had a breach of contract claim and she had a duty of good faith and fair dealing claim, statutory. But then her damages question was really only seeking damages under the policy. And the court was clear about that. See if I can move this around. It says Menchaca sued USAA for breach of the insurance policy and unfair settlement practices in violation of the Texas Insurance Code. As damages for both claims, she sought only insurance benefits under the policy. That's very distinguishable from this case. In our case, we sought insurance policy benefits under the breach of contract claim, but not under our duty of good faith and fair dealing claim. And under that claim, we had independent damages that were separate and distinct. Let me go to, if we read on at Menchaca, again, but both parties agreed that they only sought benefits under the policy. So that's important here because that's not what we were doing here. So when we're reading Menchaca, we have to keep that in mind. This is an issue about whether insurance policy benefits can be brought in a breach of duty of good faith and fair dealing case. And despite the plaintiff's, the defendant's representations, the Menchaca holding is not as broad as they say. USAA in the Menchaca case, like they do in this case, said they contended that even if its policy covered Menchaca's loss, Menchaca could not recover policy benefits unless she prevailed on her breach of contract claim under question 1. That is exactly what USAA is claiming in this case. The Texas Supreme Court said, we disagree. They did not agree with that analysis. They went on to say, while an insured cannot recover policy benefits for a statutory violation, unless the jury finds that the insured had a right to the benefits under the policy, the insured does not also have to prevail on a separate breach of contract claim because the insurer's failure to pay those benefits. And that's what we have in this case. We had a breach of contract claim for whatever reason. The jury did not say we prevailed on that claim, but they did say we prevailed on our separate and distinct breach of the duty of good faith and fair dealing claim. And Menchaca actually allows for that. possibility. So I do not think we have that issue in this case. We also, there's a case called Twin City, a Texas Supreme Court 1995 case, which is 904 Southwest 2nd 663. And that case is discussed in Menchaca, but I'd like to quote from that case. They said, some acts of bad faith, such as failure to properly investigate a claim, which is what we contended here, or delay in payment, which is what we contended here, do not necessarily relate to the insurer's breach of its contractual duties to pay covered claims and may give rise to different damages. And that's what we had in this case. Exactly. We argued, and I believe the jury agreed with us that that USAA's failure to investigate properly in this case and then failure to promptly pay caused these other damages. And so what ultimately the jury awarded were mitigation costs and all the extra costs, the additional costs to rebuild the Crossman's home. If Your Honor will recall, there was a lot of testimony about how prices had ballooned during COVID, how much more expensive everything was. So the damages we sought in our breach of duty of good faith and fair dealing were separate and distinct. In fact, I don't know if the court recalls, because I know Your Honor has a lot of cases, but there was originally proposed by, I believe, USAA, a blank in the damages question for breach of duty of good faith and fair dealing, a damages question relating to damages under the policy. And we asked that that be removed because we were not seeking damages under the policy for breach of the duty of good faith and fair dealing. We felt that these were separate and distinct causes of action with separate and distinct damages. So that was not submitted, and the jury did not decide that issue. Also, I would like to point out that if breach of contract was necessary for a finding of breach of the duty of good faith and fair dealing, then there needed to be a conditioning instruction. USAA did not object to there being no conditioning instruction, did not offer a conditioning instruction, in fact, didn't mention it at all. Further, in the Menchaca case, let me move on towards the end here. On page 23 of my PDF, the court talked about waiver. And when a party waives a complaint regarding alleged conflict in the jury's answers. So essentially the issue here is the no on the breach of contract question in our jury charge, a fatal conflict with the yes, and then the damages on both the breach of the duty of of good faith and fair dealing, and then the answers on the Prompt Payment Act questions. And essentially it seems that USAA is arguing that's a fatal conflict. And so because there was no breach of contract, then plaintiffs cannot recover on any of these. But the Menchaca court actually addressed that. They said a party waives any complaint regarding any alleged conflict in the jury's answers by failing to voice the complaint before the jury is discharged. Now, Your Honor asked the parties if anybody wanted to talk to the jurors when we got this charge back. If we wanted to canvass the jurors and see what they did or send back additional instruction to see if they needed to go back and look at any questions, and both plaintiffs and defendants said no. So Your Honor offered us the opportunity and we said no. So I think any fatal conflict at this point has been waived. And to see whose duty that is, the Menchaca court addressed that. They said, we agree with the courts of appeal that to preserve error based on fatally conflicting jury answers, parties must raise that objection before the trial court discharges the jury, which was not done in this case. USAA is trying to argue it now, but it's too late. And then they go on and they talk about, they had a similar circumstance here in Menchaca. And so they said in the jury's answers to questions 2 and 3 in Menchaca, which were the bad faith questions, Menchaca obtained all of the findings necessary to recover on her statutory violation claim. And USAA is the party who must rely on the conflicting answer to question 1 to prevent Menchaca from recovering based on answers questions 2 and 3. As the party who must rely on the conflicting answer to avoid the effect of the answers that establish liability, USAA bore the burden to object. Your Honor, USA didn't object in this circumstance. They didn't ask for the jury to be questioned further. as the court knows, a court has a duty to reconcile any apparent conflicts in the jury's findings if reasonably possible. I think the jury's findings are actually quite reconcilable in this case. We have one major factual difference in our case to Menchaca, and that is a set of 2 payments that USAA made to my clients a week before the trial in this case. So I don't know if your honor recalls, but no payments were made for payments were made initially, no payments, no inspections were performed for 2.5 years or so. And then about a month before trial, USAA requested an inspection, which we of course granted. And then USAA submitted 2 additional payments to my clients in the amount of about $68,000. And those are detailed in plaintiff's trial exhibit 53. And they were in the testimony of Mr. Jamie Fair, who was a representative of USAA, saying that we decided after the inspection that we needed to make those payments. Well, that's highly distinguishable in this case from Menchaca, where there were just never any payments made. So what we have is a circumstance where a jury could find, okay, maybe at the time when they got the jury charge, there was no longer breach of contract. I'm not saying plaintiffs agree with this analysis, but if we're trying to reconcile any apparent conflicts, we have to look at all of the evidence and everything that was presented and see, could a jury have reasonably come to this conclusion? I think a jury could reasonably have come to the conclusion that at the time they received the charge, USAA paid what it needed to pay with that additional $68,000 in payments received a week before trial started. And so maybe no additional funds were required under the policy. But when you move to the breach of contract, breach of the duty of good faith and fair dealing, USAA had not complied with its obligation to reasonably investigate since it had waited so long, or to promptly pay. The jury ultimately found that USA did not promptly pay because it put a date of July 9th, 2020, by which USAA had all of the information it needed, and it didn't pay within 60 days of that. So all of the findings actually.
Just a second. We have the attorneys here on the DC 232616, Mr. Lemoyne, I think, and Ms. Wallace, is that right?
Yes, Your Honor.
Yes, Your Honor.
So I just wanted to make sure, because I've had this issue come up before. You guys are about to file something under seal. I have do you already know about this?
Yes. Is it for under seal or for you only? There's 2 ways they can do it.
Right. So if you want this to be considered, I think it has to be filed under seal. Yes. I can't do an in-camera inspection of evidence under a summary judgment practice. And so it says here, Hayden Baird, I don't know who that is.
Yes, Your Honor, we call. Yes.
We filed a portion of our summary judgment under seal and are seeking clarification. So it's the clerk's office who are responsible for making sure things are actually sealed. Not with this particular clerk, she's done a great job, but I've had clerks in the past who have got documents and didn't seal the correct thing, or didn't seal things quickly enough, or whatever. And so I wanted to make sure that you guys were communicating with her to make sure that it was clear what exactly was supposed to be sealed and under what authority it was going to be sealed. And so have you been in communication with the clerk's office about this?
I think only with the court coordinator. Have you also been in touch with the clerk?
I spoke with the clerk.
He spoke with the clerk very briefly. I think the confusion on our end, Judge, and the clerk that's in the courtroom was whether or not we needed to appear in person to file the portion under seal, or whether that could be done via the online portal. And then how Your Honor wanted a copy of the sealed portion, just to make sure that we're not running afoul of anything. And we are filing under seal pursuant to our protective order.
For admin, we can lock it even if they put, because when e-filing, if you put contain sensitive data, it was supposed to lock it when you accept it. But per admin, we have to have an order on file signed by you.
We already have a protective order on file.
No, they want to order to seal on file.
They want a specific order to seal.
We can file a motion. We have that on ready for Your Honor as well.
If you want to e-file it.
think the protective order doesn't say seal. It just says that it's, certain confidential information wouldn't be put in the public record. So I would assume what the clerk needs is an order from Your Honor pursuant to a motion to seal, which we have ready and can submit to you, Your Honor.
But I mean, if she wants to bring it in person, per you telling me I can do it, but through e-filing, the admin will wanna order and file.
And so as I understand it, the response is due today, is that correct?
Yes, Your Honor.
Logistically, I'm not sure how to do this because I'm about to leave. I'm not gonna be able to sign anything unless you can get someone here in the next 15 minutes. I'm not gonna be able to sign anybody, and I don't have an associate judge right now, so.
We can get someone there within 15, 20 minutes. I can't guarantee that it'll be in the next 10.
You have an order for me to sign, and then I think that the key thing here is that I guess this is an appendix that you want, a particular appendix that you want sealed.
Yes, Your Honor.
So one thing I've been told of is, you're telling me something new, is that they can't seal part of a document. They can only seal an entire document. So I assume the appendix you're filing is all under seal.
We've got one appendix not under seal and one appendix under seal.
Okay. And Mr. Lemoyne, are you opposing any of this?
No, Judge, I have no idea what they're sealing. So that was, and I got an email that said be on the call. So I thought it was to fight over what was going into. I'm happy with them sealing whatever it is, whatever it may be.
What my understanding, unless the rules have changed, is that you would need to do a temporary sealing order, then you would need to go through the whole process under 76A to seal. That includes posting and all that kind of stuff. That's how I think if the clerk's office is sounding like they're getting a little more strict, which is understandable, on what they require to seal. And I think that it does require, as you can do a temporary 76A. Is that what you have for me to sign, Ms. Wallace?
I believe so. Yes, Your Honor.
Okay. Well,
Do we head up there to bring that to you now?
If you have to leave, Judge, I'll do it this once final, but it's gonna have to be the whole thing, the whole motion.
just this one appendix.
Yeah.
So just the appendix that needs to be sealed. Can you, if I tell you to, will you take, what I would suggest they do is they e-file everything that's not under seal and they bring what
Well,
needs
they
to be.
can file, she can file her appendix separate if she wants to.
No, I mean, but the part that needs to be sealed, have her bring that in person. So we make sure that it's clear what's sealed and what's not. So what I'm gonna say is you guys are gonna
Email you the order right now, Your Honor, such that it's not something you're having to be detained to wait for. And then separately bring the sealed portion.
Yeah, she says that she'll go ahead and seal it since I've already told her to do it.
Okay, great.
Bring the order with so e-file all the unsealed stuff, the sealed stuff, bring it in person, and then you can scan it, right? Then she'll scan it, and then bring the order on top of whatever is supposed to be sealed, so I can sign that tomorrow morning.
Okay, thank you so much, Your Honor, and thank you to the clerk as well.
This is Marissa. You're talking to Marissa. Make sure that they bring this to Marissa.
Marissa, what's your last name?
Gomez.
Gomez. Awesome. Thank you both so very much.
Thanks, guys.
All right. Thanks,
And this is the cause number. Do you need the cause number?
Yeah.
Thank you so much. All right, you guys are excused. Let's go back on. Let's go back to Crossman. All right. Response, Ms. Sanji?
Yes, Your Honor. I want to start with that, quite frankly, there was no conditioning instruction because under the good faith and fair dealing claims, the Crossman sought mental anguish. That could not be conditioned upon any sort of breach of contract. So there should not, I doubt the court would have even given a conditioning instruction should it have been requested. But the fact of the matter is what the plaintiffs recovered under their good faith and fair dealing are not independent injuries because they flow from the loss of benefits. The Menchaca case specifically states in discussing the aspect of independent injury claims. Well, wait, step back. Menchaca specifically requires you have to first show the entitlements to benefits. Here, they did not prevail on entitlements to benefits claim. As a matter of law, they're not entitled to any damages under good faith and fair dealing unless they are truly independent injuries. The aspect of the independent injury applies only if the damages are truly independent of the insured's right to receive policy benefits. And this is Menchaca at 499 and 500. It does not apply if the insured's statutory or extra contractual claims are predicated on the loss being covered under the insurance policy, or if the damages flow or stem from the denial of the claim for policy benefits. When an insured seeks to recover damages that are predicated on, flow from, or stem from policy benefits, the general rule applies and precludes recovery unless the policy entitles the insured to those benefits. And actually, the issue in Menchaca, Your Honor, was it dated back to a conflict in opinions between the Vail case before the Supreme Court and the other cases that had existed prior to Menchaca. But the second aspect of the independent injury rule, as set forth in Menchaca, is that an insurer's statutory violations does not permit the insured to recover any damages beyond policy benefits unless the violation causes an injury that is independent from the loss of the benefits. They went even further, and they say we have further limited the natural range of injury by insisting that an injury is not independent from an insured's right to receive policy benefits if the injury flows or stems from the denial of that right. They did not prevail on a contract claim. They did not show they were entitled to any additional benefits. That's what this jury decided. That's how the question is worded. That's why the jury answered no to question 3. What's even more interesting is, while Ms. Bella is here arguing that the damages recovered under the good faith and fair dealing were somehow independent, they largely track the damages she sought under the policy question. And in fact, she argued, and the court set forth in those damage questions, consequential damages. In particular, the question number 4, category 3 in the jury charge, which I understand the jury did not answer this question because of the no answer breach of contract. The specific category is the reasonable and necessary expenses incurred by the Crossmans in attempting to mitigate further damages that were a natural, probable, and foreseeable consequence of USAA GIC's failure to comply. That is, they have now asked for those damages to mitigate as an element of their good faith and fair dealing claim. Clearly, it is not. It is not an independent injury that stems from, flows from the denial of the benefits, of which the jury found there was not a denial of the benefits. The only truly independent injury that the Crossmans sought was mental anguish damages. And the jury zeroed them out on those mental anguish damages. She wants to try to argue, I'm sorry.
So I guess my question is, what case law is there on, I see that you have this case Argonaut, Great Central Insurance Company versus MLLCA. And it says holding damages for lost profits, incidental expenses, and reduced sales price because MLLCA could not complete repairs, all flowed from the alleged breach of contract, were not independent injuries. Then the second case you cite to doesn't really give me any facts, so I'm not sure what it says, but the Valentine case. Ms. Bella, what cases do you have that kind of establish, to kind of support your position that this would be an independent injury?
Well, Your Honor, the biggest case is the Twin City case that I cited to earlier, that 1995 Texas Supreme Court case, where they talk about acts of bad faith giving rise to separate and independent damages that don't necessarily flow from the policy. And those can be all sorts of things. In this case, if Your Honor will look at the charge or recall the charge, we had question number 3, which was breach of contract. Question number 4 was damages specifically relating to breach of contract. Then we had question number 5, which was duty of good faith and fair dealing. And we had question number 6, which was damages specifically related to breach of duty of good faith and fair dealing. In Menchaca, the whole case became an issue because they didn't have it separated that way. They had one damages question for both their breach of contract and their breach of duty of good faith and fair dealing. And so they were trying to determine, are these separate? Did the jury have independent damages? What were the damages related to? Were they related to the breach of contract, related to the duty of good faith and fair dealing? In this case, we have a conditioning instruction on 6, which is where we have the answers filled in, talking about don't answer 6 until you've answered 5. And then question 6 specifically says that the damages for question 6 have to have been proximately caused by the conduct found in response to question number 5. So we resolved that problem, that potential Menchaca problem, by setting the jury charge up this way. I mean, that was frankly a big reason to set this up this way. It was also the reason that I requested that there not be any blank in question number 6 regarding policy damages, because I didn't want to create a Menchaca issue. So it was in an original draft, one of the early drafts of the jury charge, and we actually took that out because I just knew a Menchaca issue could come up in this case, and I didn't want one. So I asked that be removed, and it was removed. And so the questions on 6 are specifically related to breach of duty, good faith, and fair deal. Those are independent. All of the evidence at trial was independent. The restoring the Crossman's home to its pre-tornado condition, this was all of the evidence we had about COVID era ballooning the costs and how expensive it became. It's not necessarily costs that were recoverable under the policy. These are additional costs. And then reasonable necessary expenses incurred by the Crossmans in attempting to mitigate further damages. That is a different question. It's a different damages question that was on number 5. We had a mitigation, I'm sorry, on number 4, we had a mitigation of damages blank on question number 4 that would have been responsive to breach of contract, but the language was different. And it was specifically related to being a natural, probable, and foreseeable consequence of USAA GIC's failure to comply with the insurance policy that it would have found if the jury had found in response to question number 3 a breach of the insurance policy. So yes, there was mitigation, but this would have been mitigation covered under the policy, because the policy did cover some mitigation expenses. That's what we asked for in question number 4. Question number 5 is separate and additional. What mitigation damages were a result of the actual bad faith? And so I think we already fixed our Menchaca problem when we set the jury charge up this way. I think what USAA is arguing in our case here is what the Texas Supreme Court said in Menchaca is not correct. You do not have to have breach of contract in order to recover on breach of duty of good faith and fair dealing. And I understand Menchaca is long and confusing, and it's a plurality, and then part of it's a dissent, and it's quite the case. But I don't think that holding applies here to our facts. And
so the only case you really have that supports your position is a pre-Menchaca case, right?
A pre-Menchaca case that is cited in Menchaca. Menchaca specifically talks about Twin City and seems to approve of it. I don't think they say I approve of Twin City, but they cite to it and discuss it.
How do you distinguish this Argonaut case?
Argonaut is again a case where they were seeking insurance policy benefits. These are these cases, and there's a whole line of them, where someone's seeking insurance policy benefits under the breach of duty of good faith and fair dealing. And so that does get very confusing. And so if you're seeking, you can't get policy benefits under breach of duty of good faith and fair dealing if you don't have breach of the policy. That is true, but that's not what we were seeking here. So the line of cases saying that, where you have to have the breach of contract first, that's because you had to have that breach of contract, and then under duty of good faith and fair dealing, you've got to have the damages under the contract. Our case, there was not even a dispute that this contract applied, that the policy applied. I mean, they'd made thousands of dollars, hundreds of thousands of dollars of payments under the contract. It was the amount, should they make any additional amounts of payments? So, sometimes you'll have in a jury charge that very initial question, does the policy even apply? We didn't have that here. It was presumed And in the pattern jury charge, I think it'll say you only put that question if it's actually in dispute in the case. We didn't have that dispute in this case. Everyone agrees that the policy applies. It's just the amount paid under the policy was really what ended up being an issue in that breach of contract claim.
A brief response.
Yes, Your Honor, I believe you focused on the correct case, which is the Argonaut case. In fact, in Argonaut, they sought as their extra contractual damages the lost profits, the out-of-pocket expenses, and $12,500 for a reduced sales price of the gas station. The court, while MLLCA specifically argued that those were independent injuries, the court specifically disagreed. Each of these forms of damages was a natural extension of Argonaut's failure to pay the additional $95,000 in policy benefits. That case tracks Menchaca. That case tracks our facts here, which is what she is seeking and what she sought for her good faith and fair dealing damages are those that stem from an alleged breach of contract or failure to pay policy benefits. And here the jury specifically found there was not a failure to pay policy benefits.
So I guess why is the language different in question 4 and 6? Why is the language for damages different in 4 and 6? Ms. Anji.
Why is the language different? Well, Your Honor, actually, we objected to those damage questions. They were not proper measure of damages because of this Menchaca issue. They flow from the alleged breach of policy or failure to pay policy benefits. Again, the only independent, and an independent injury is so rare, even the Menchaca court, we have in fact as yet to have encountered one. Why is the language different? That's the language that Ms. Bella argued for, that you permitted, that we objected to, Your Honor, because we did not believe it was a proper measure of damages to this question. And further, all she did in the damages question with respect to the mitigation damages is remove the consequential damages language. That's all she did. Very much admission, I think, on her part, that the mitigation damages are in fact consequential damages that she's seeking that flow from the alleged breach of the policy. But we did object to this damages question, Your Honor, because it is not a proper measure of damages. They are not injuries that are truly independent, as would be warranted. And so under Menchaca and its progeny since then, you still have to establish that it was a breach of the contract and entitlements to benefits to recover those.
Okay, let's turn to the issue of motion to assess litigation costs. I've read the briefing, so let me hear just the response to that.
Yes, Your Honor, there's several points. First of all, the law is interesting on this. There are far fewer cases than I would have expected, since this has been in place for 20 years. But, number one, you have to timely invoke the offer of settlement rule. The actual language of the offer of settlement rule is that it has to be 45 days before the case is set for conventional trial on the merits. And then if you ever get an extension on that, it has to be an actual order from the court extending that time period, not just some general order. It has to be a written order from the court extending the time period. And our original trial setting in this case was September 28th, 2021. And although that was continued many times, there's never any order from the court extending the time by which an offer of settlement procedure can be implemented. And so the defendants opened the offer of settlement procedure in November 2021 after the initial trial setting. So A, I don't think it was timely. B, the offer that they actually made, the offer of settlement they made, it included a number of unreasonable conditions and non-monetary claims. They wanted confidentiality. They wanted a number of undefined indemnities. They wanted anti-disparagement provision. We believe those were unreasonable, and because they were unreasonable, the court can certainly find them unreasonable. And so any rejection of an offer made subject to a condition determined by the court to have been unreasonable can't be the basis for an award of litigation costs. Your Honor, we would submit that asking for non-disparagement provisions, asking for indemnity just generally, indemnities without defining what those are, that those are not reasonable in terms of a formal offer of settlement proceeding. Also, the jury didn't actually award significantly less than the offer of settlement in this case. I know there's a dispute, as we discussed with Menchaca, about what is going to be upheld here. But if you take the jury's $175,000 approximate value that they awarded for the breach of duty of good faith and fair dealing, plus the prompt payment penalties, then I know Ms. Sanji has an objection to the percentage I used. I used 18%. She thinks it should be 5% plus the prime rate. She's probably right. Even using hers, 13.5%, our damages are $251, $296.68, which is above that 80% limit. So even on that basis, we're not significantly below the offer of settlement, because we would have had to be below 244 basically, and we'd be at 251. A big one here, Your Honor, and I could find no case law on this, I'll admit it, but this offer of settlement was made in 2022, January 2022. In August 2023, USAA actually paid my clients, paid them money, $68,000 additional. So, 18 months or so after, even more, after my clients could have even accepted this offer of settlement, the entire case changed. Because at that point, a week before trial, when they received an additional $68,000, my clients reduced their claim for breach of contract in this case by $68,000. We reduced the amount we were asking the jury for by $68,000. And although the statute is clear that you can have future offers of settlement, future settlement offers, and that doesn't affect your abilities here, that's not what was going on here. Here, USAA actually made additional payments. And so that significantly impacted this case and the value we were asking the jury. So if we're now asking the jury $68,000 less at the time of trial, then they're likely to award $68,000 less. And so that affects this offer of settlement procedure. Allowing a party to manipulate the procedure like that, which is what this would allow, by making very large payment way after a time period for expiration of the settlement has gone, is unjust and unfair, and this offer of settlement procedure should not even apply in those circumstances. Lastly, I'll just say the attorney's fees that Ms. Sanji attaches, it's $300 some odd thousand in attorney's fees that she has attached to her motion, were never produced in this case. Never got a single attorney's fee bill, attorney's fee affidavit. Ms. Sanji was designated as an expert, but none of the fees were ever produced. I think those needed to be produced during production in this case, certainly prior to the time of trial, and it shouldn't be produced just for the first time ever post-trial and a post-trial motion. So we would ask that all the attorney's fees be stricken on their motion.
Response briefly.
Yes, Your Honor, I'll kind of go backwards, I guess. With respect to her claim about the attorney's fees, this is an offset. We are not seeking to recover the attorney's fees. Under the statute itself, it is an offset. And Ms. Bell has had those documents since November 3rd, and 167.5 permits discovery on attorney's fees. She wanted to challenge them if she wanted to think they were inappropriate. She certainly had the opportunity. 167.5B says, on motion and for good cause, the party against whom litigation costs are to be awarded may conduct discovery to ascertain the reasonableness of the costs requested. This is not something that was ever even relevant until we got a verdict. Because quite frankly, once we properly invoked the procedure and followed the procedure to invoke it, This only ever comes up and becomes relevant once we get the verdict. There was never any need to produce these, nor were we required to produce these. In fact, rather, I could have either produced the attorney's fees, or I could have simply showed up today and testified under Ormuz as to the reasonableness and necessity of all of the fees. But because we keep diligent time records, we submitted our time records. We go back to Ms. Bella's first point that we did not timely invoke it. Absolutely, we did. The statute foresees a conventional trial on the merits. Again, because this procedure does not even, or statute doesn't even come into play until we get a verdict to make that determination, the statute clearly is focused on a trial on the merits. In fact, in her response, there's a case that Ms. Bella refers to vaguely. However, that case itself, the Thompson case, even the procedure was not invoked until after the second continuance. So there is simply no basis whatsoever to say this was not timely invoked. In terms of the conditions, again, the Supreme Court set out the procedure, 167.2C, conditions of offer. An offer may be made subject to reasonable conditions, including the execution of appropriate releases, indemnities, and other documents. An offeree may object to a condition by written notice served on the offerer before the deadline stated in the offer. No objection was served on us. There was simply no objection made pursuant to the statute. The procedure hasn't been followed, so arguably she has waived any objection to the conditions. But further, these are the exact type of conditions that the rule sets forth may be included in our offer. So we've timely invoked, the conditions are reasonable, appropriate, and there was no objection made to them. A significantly less issue, Your Honor. Quite frankly, her numbers are wrong in many regards. One, you've heard her now argue that these are not policy benefits she's seeking, that they're somehow some sort of independent injury. Well, if it's an independent injury, if the court were to find that they were an independent injury, 542 does not apply to independent injury damages. It only applies to policy benefits. They did not, under her theory, they did not recover any policy benefits. So to determine significantly less favorable, no interest should be included. A second point is it would be at the time of the offer. The offer specifically includes this amount's being offered inclusive of interest and attorney's fees. The 279 is well in excess of that. And well in the 174 recovered, calculating it, actually the interest rate that should be used is the interest rate in place at the time the offer was made. In January of 2022, under 542A, rolling then into 542.060, the interest rate was only 10%, not 18%, not 13.75%, which is what I believe it would be today. Applying the 10% to whichever number, if you apply, because she'd already conceded that mitigation damages appear to have been consequential damages stemming from, not entitled to. But applying either, which I don't think, quite frankly, and the law does not support them being entitled to 542 interest, your numbers are still less than 80%. I did the calculation.
How do you deal with this issue involving the additional 68,000 being paid?
Certainly, Your Honor. That was holdback. That's an entirely different issue.
Wait, say that again. I didn't understand what you said. You said
the amount that was paid. The amount that was paid was holdback under USAA's original adjustment of the loss. They would not have been entitled to those benefits until such work had been completed to entitle them to those benefits. It's a policy where the ACV was paid, and after an inspection in September, the adjuster made the decision, as he testified to, that there was sufficient evidence to go ahead and tender the holdback amounts. That doesn't come into play at all. And quite frankly, they sought far more than this in terms of benefits. On their contractual claims, ultimately they sought $519,281.54 on the cost to fix the home. They sought $53,000, roughly $89 of mitigation costs, and an additional $300,000 of storage and apartment rent. So it's kind of a little bit disingenuous to try to argue, oh, it would have been entirely different because we would have been asking for so much more money. They had not shown themselves entitled to those benefits until such time as the inspection occurred.
Well, let me take a step back. So there's subsection 167.2C, conditions of offer, that says an offering may object to a condition by written notice served on the offer or before the deadline stated in the offer. Was that done?
No, Your Honor.
Your Honor, it was not, but may I point out that we may object, but I believe the case law is clear that we're not required to object, and a court can still find conditions to be unreasonable even if no objection was made.
In the Thompson cases, they did object, Your Honor, that's cited by Ms. Bell in her briefing.
Are there cases where they didn't object? I mean, it does say may object. I guess it says it doesn't have to object. It says rejection of an offer made subject to a condition determined by the court to have been less unreasonable cannot be the basis for an award of litigation costs under this rule. It
The
says
objection must be preserved, Your Honor.
a condition to which no objection is made is presumed to have been reasonable. Yeah, I think you have, I have to presume that that was reasonable, the confidentiality was reasonable.
Your Honor, I believe that you can presume, or it is presumed, but it does not mean a court cannot find otherwise. I think in an offer of settlement, I mean, generally speaking, you do not even see things like confidentiality and anti-disparagement provisions when a party is truly trying to do an offer of settlement, because they don't want to get in the way of the rules on these types of things. I mean, here we don't even have just confidentiality, which, you do see that a fair amount, but we have non-disparagement provision. That's a different ball of wax, and I think those are generally unreasonable.
I don't know. So 167D says non-monetary and accepted claims not included. An offer must not include non-monetary claims and other claims to which this rule does not apply. I guess, how does that impact the non-disparagement?
Well, Your Honor, I don't know about non-disparagement. There is a case, Oryx Capital Markets, which is cited in our brief, and I understand you may not have that in front of you. It's a San Antonio, Texas Court of Appeal case from 2010. And it talks about these non-monetary claims. And in that case, it was actually a defendant made a claim and sought indemnity in addition on not a claim, I'm sorry. Defendant made a settlement offer, and as part of that settlement offer sought indemnity, and the court said that noting that the offer included indemnity, noted that non-monetary claims may not be included in the settlement. So when a defendant is asking for indemnity, could be considered a non-monetary claim, and therefore that makes the offer of settlement null and void.
Actually, I disagree with her interpretation of the Oryx case. That's not what it said, held, and further, there were additional random conditions that were included in that. And in fact, the rule specifically envisions reasonable conditions, including execution of appropriate releases and indemnities. So just because it includes the indemnities language does not make it an unreasonable condition. It's not unreasonable as a matter of law, and she has not provided you any cases that actually support her position.
Well, the Thompson case also talks about indemnity and being a non-monetary claim.
And this language is not super clear. It says execution of appropriate releases, indemnities, and other documents.
I'll note the language does not include confidentiality or non-disparagement.
Yeah.
Your Honor, again, there was no objection to those terms. Those are typical terms in a settlement agreement. There was no objection to those.
And it says that an offer may be made before the defendant's declaration is filed within 60 days after the appearance in the case of the offeror or an offeree, whichever is later. And it may not be made within 14 days before the date the case is set for conventional trial on the merits. But when was this made exactly?
January 6th of 2022, Your Honor.
And when was the trial setting?
The original trial setting was September 28th, 2021.
You're saying it's too late because it was filed after the original trial setting?
Yes, Your Honor, because of the language there, they're not saying when the case is tried, or they're not saying 14 days before a conventional trial on the merits is held. They're saying 14 days before the case is set for conventional trial on the merits. The case was set September 28th, 2021. There's very clear case law that a court can extend that deadline. And USAA asked for continuance many times, and they could have always put that in the order, but it's not in any order. There's never an order requesting extension of that deadline.
Is there any cases that interpret this section about time limitation?
I'll tell you, Your Honor, I could not find one.
Ms. Sanji?
I'm sorry, I didn't hear the question.
Are there any cases that interpret 167.2E subsection 3, what that means?
Yes, Your Honor, there are two cases. There is the Logsdon case, one second, which is 2015 WL 7690034 out of the Fort Worth Court of Appeals.
What does it say?
It focused more on the fact, Your Honor, of whether or not a court could extend or change the time to respond to an offer, which the said specifically they did not. It did not have to address the issue specifically on trial on the merits of this time limitation. Quite frankly, this time limitation specifically says, oh, I guess I'm not sure what your concern is on the time limitation.
I guess I'm trying to figure out the policy reason for this, which is you can't make it within 14 days of trial. I assume there's a reason for that. Trying to guess what that reason is, but I'm assuming it's because you don't want this to continue to happen. Like if you make an offer during trial, or you have to have a time period. The purpose of this is to try to encourage settlement. If it's done after trial has started, the purpose to reduce settlement or to encourage settlement is to reduce litigation costs. This did nothing to reduce litigation costs. It was made after the trial setting or after a trial had started.
Yes, Your Honor. I believe there's a few cases that talk about, and it's in a post-judgment context, whether prejudgment interest can be considered when determining the amount. And those cases were saying, well, look, when we're determining whether you are within that settlement range, the significant settlement range, we don't even include prejudgment interest because this is supposed to be an offer of settlement procedure done very early in the case to prevent even the need for that prejudgment interest. You're doing it very early. Prejudgment interest doesn't even start to accrue until 180 days after the case is filed, generally speaking, or notice of the claim. And so we don't include that prejudgment interest when we're determining it because the whole idea is not to have it. So that the Texas legislature's idea, as I understand it, in putting this in place was, let's promote early settlement of claims. Let's see if we can get rid of them. And if not, we're not going to burden the parties later on with this, but that is a procedure that's supposed to go on early in the case. And in this case was implemented a year and a half, almost a year and 3 or 4 months after the case was filed.
Well, Your Honor, the statute actually is meant to do more than just encourage early settlement. It's actually to place some risk, so to speak, in play to the parties. Here, the rule specifically provides for, and all we are seeking is an offset of any judgment with respect to it. We cannot get, as a defendant, any affirmative relief under it. We can simply offset the amount of the judgment. So it's more than just early settlement, and it's not simply an issue of you can only do it with the initial trial setting. Both Chapter 42 of the Civil Practice and Remedies Code, as well as 167, speak to a conventional trial on the merits. Again, as I raised earlier, this doesn't even come into play until you have a verdict. So the fact of the matter is you do not have to invoke it before the first trial setting. It simply says before trial. The trial here occurred beginning on September 11th, 2023.
Yeah, I mean, I don't think the statute is at all clear on this point. It says it's set for, it may not be filed within 14 days before the date is set for a conventional, I don't know what that means, conventional trial on the merits, except that I guess that's maybe distinguishing summary judgments, except that an offer may be made within that period if it's in response to and within 7 days of a prior offer. It doesn't say the first trial setting, but it also doesn't say that. I mean, it just doesn't say. I mean, I don't know what this means. I don't think it's super clear. I do think it's not an unreasonable reading to say it's a first trial setting, but there's not a whole lot of guidance here, it sounds like. So nobody's ever interpreted that to mean first trial setting or the trial setting that actually went. There's just no case law on that.
I was not able to find any, Your Honor.
Ms. Sanji, doesn't sound like you found any either.
It was untimely because it was 30 days before trial.
Yeah.
That's the closest.
Your Honor, in the Oryx case, which Ms. Bella cited, it was untimely because it was invoked within 30 days of the trial setting. Of the trial starting, of the trial starting, not the original trial setting, but of the trial starting.
Was there previous trials? Did they discuss this issue of initial trial setting or not? You're very able appellate counsel there is saying no, it isn't. So I don't know why you don't let her talk. She's very able. So
well, I'm happy to let her talk, but I thought it was one lawyer aside.
Same. I wanted to respect the court's procedure. The court does not talk about this issue. It was the closest I could find where they are interpreting whether or not the offer was timely. And they say in that case, it was untimely because it was only 32 days before the trial began on July 20th. So they're looking at the rule and saying it's when trial began and that's why it was untimely. But that they don't otherwise go into discussion of it.
All right, I got a rule. I'm going to go ahead and rule on this. I'm going to deny the motion to assess litigation costs. I want to make it clear, though, that I agree with Ms. Sanji that the additional conditions needed to be objected to, I believe, under 167.2C, but I do think this was untimely. I'm, shooting a little bit in the dark here because I don't think there's any case law, but I think it should be made 14 days before the first trial setting, the conventional trial on the merits. That makes the most sense to me. There's no case law to the contrary. And for the other reasons stated by the plaintiff. And then I'm going to grant judgment in favor of the plaintiff. But I think you had 18% interest in the judgment. I think you guys agreed it should be 10.5. Is that correct?
I think it should be 13.75, Your Honor. Well, it should be 8.5 plus 5%. It should be 13.5.
Your Honor, just so I can make sure, my objection to her judgment in that proposal that she's got now is given her admission that these were not policy benefits, and she's attempting to admitted their independent injury. 542 applies only to policy benefits to the claim itself, not to any sort of extra contractual claims. So under 542, she should not be entitled to any interest if, in fact, the court is finding these are independent injuries which she can recover under the good faith and fair dealing.
You mean any injuries in excess of 5%?
The penalty interest that she seeks under 542, Your Honor, only applies to policy benefits.
Yeah, I think that's correct. But doesn't she also recover under? Isn't there going to be a separate recovery for question based on question 7?
No, Your Honor, because she has not recovered policy benefits.
Your Honor, I believe that's what Ms. Sanji's talking about. That's the prompt payment statute. She's 542 is the prompt payment statute. So
Okay.
the policy benefits argument is, you can cover the breach of contract policy benefits, or if any of the monetary claims under the breach of the duty of good faith and fair dealing were for policy, which means, from the policy or stemming from the policy, then the percentage would go on those two. If the court finds that those are not stemming from the policy, then I don't think we can use those for prompt payment statute. If they are stemming from the policy, as Ms. Sanji has claimed, then the prompt payment statute applies to those claims.
You can't have it both ways, Ms. Bella. So if it's an independent injury, you would not get the prompt payment, so you would get regular interest then.
Yes, Your Honor.
Okay, get me a new judgment on this. Get me a new order on the motion to assess litigation costs or deny motion to assess litigation costs. Please share that with the opposing counsel. Have able appellate counsel take a look at this as well, and get that to me by this Friday. I'd like to have it signed off as the form by both sides, and it needs to say at the beginning that this was heard on December 11th, 2023. Okay, guys?
Yes, Your Honor. Thank you.
Thank you. You guys have a great rest of your day.
Okay.
I know that you gotta get out of here. Wanted to introduce you to Nebo.
Hey, how you doing?
Christopher Nebo is the one that I was telling you about that has the law degree.
Oh, okay. Yeah. What are you here at this building usually, or? Yeah, we'll come up.
He's in Williams Court.
Okay, well, come by when you have a break. I have to get going to the hospital, so I have a friend who's in ICU. So, but yeah, I would love to talk to you about it. I just need to take care of this last hearing. But nice to meet you. Okay, thank you.
We do have a trial tomorrow, so probably Wednesday will be best, huh?
Come by whenever you can. All right, are both sides here on the Foster case? All right.
Yes, Your Honor.
Yes, Judge.
Counsel is here.
Okay, so I understand that this case has a minor involved. Is that correct?
That's correct, Your Honor.
And you guys have not requested a guardian ad litem. Is that correct?
That's correct, Your Honor. The settlement amount for the minor plaintiff is $5,000. His father has custody of him. It's our belief that it's not really under the present circumstances, given the small amount of the settlement. We don't think it's necessary at this time.
What were his injuries?
It was basic car accident, injury, cervicalgia, whiplash.
Yeah, I usually require a guardian ad litem for cases of that size. 2,500 to 5,000 is usually where I kind of the minimum. If it's a situation where they just went to the emergency room, I don't usually require it. So I usually do require it for that. So I usually use is the client, it's Brian Foster. Fabiola Segovia is pretty quick on these kind of things. You guys know her?
I don't, Your Honor.
I don't, but that sounds good.
Okay. Why don't you guys get a motion to appoint a guardian ad litem? I'll try to get her. I'll tell her this and try to get this done quickly for you. Okay.
Thank you, Your Honor.
All right.
Thank you.
Thank you. All right. Bye-bye.
Thank you.